Welcome to St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. A group of activists had filed a formal complaint over the Freeburg, Illinois Mighty Midgets. They say the school mascot violates federal anti-discrimination law. Would any judge agree? And a federal judge appears poised to strike down the state's revolving door ban, which bars lawmakers from leaving office and immediately turning around and lobbying their own colleagues. How could this law aimed at good government be unconstitutional? And a Missouri summer camp hugely popular with evangelicals was accused of hiding its history of sexual misconduct. But a judge said not so fast. How did they get off the hook? We have big legal questions before us today and a panel of top lawyers to help us answer them. Yes, today is our monthly legal roundtable. And this month, our panel includes Eric Banks. He's a former city councilor for the city of St. Louis and an attorney and mediator at Banks Law. Eric, welcome back.
Thank you.
And with us today is Susan McGraw. She has answered the call to fill in at the last minute. We are so grateful that she is here today, always so fast on her feet. She is a professor at the St. Louis University School of Law, director of its Criminal Defense Legal Clinic, and today I am more grateful to her than anybody in my life. Susan, welcome.
Thank you, Sarah.
And finally today, making his legal roundtable debut is Sean McLean. He's a partner at the law firm Mickus O'Toole. He focuses on labor, employment, and education law. Sean, we are so glad you're here with us today.
Thank you. Happy to be here.
So, a federal judge issued a restraining order earlier this month blocking enforcement of Missouri's revolving door ban. The ban seeks to enforce a cooling off period between when lawmakers leave office and when they can register as lobbyists. Former State Representative Tony Lovasco, a Republican, filed suit in Kansas City's Western District challenging the ban. A judge said the state could not enforce the ban against him for 14 days. That was supposed to give time for a hearing. Sean, how should we read this temporary restraining order? Does this mean he's likely to prevail?
Yeah, that's one of the factors whenever the courts look at these TROs. And so the court in this particular case, they looked at his likelihood to prevail, and they found, looking at a similar case that was decided in July of 2024, that this particular case fell within the same precedent as it. And so they decided that essentially it was almost an identical case and that he was likely to prevail on the merits. And they gave the parties 14 days, as you noted, in order to, determine whether or not there was additional evidence to decide at a preliminary injunction level. And the parties jointly said that there was nothing else for the court to consider, and the court did enter a preliminary injunction on this case. So there's an injunction currently entered. It just applies to Tony Lovasco in this particular statute, not to everyone else, but just to him. And prevents the Missouri Ethics Commission from enforcing that particular statute.
So Tony can now go out and lobby. Somebody who's similarly situated and has recently left office and would like to become a lobbyist, is the idea that if this continues down the path it's on, they will then be allowed to do that as well.
Yeah, I mean, I think at the end of this, the court is going to they'll proceed on the merits, right? And they'll look at the case itself. But right now, the court has given every indication that it's going to decide that this case is precedentially just like the prior case that got tossed out in July of 2024. And actually in the decision, they said there's really only two differences. In the prior case, it was different government employees. And in the prior case, it was just the length of time. I think it was 2 years versus 6 months. And so, at the end of the day, they said, look, this is basically the same type of First Amendment case as the other case that that the Eighth Circuit already decided. So we're going to follow the Eighth Circuit Court of Appeals. And yeah, I mean, if it gets tossed out, then, the Missouri Ethics Commission, which is charged with enforcing the statute, wouldn't enforce the statute.
So First Amendment, we might not think of lobbyists as having First Amendment rights, but I guess everybody has First Amendment rights. Susan, how does that play into this year?
Well, I mean, it's a First Amendment right to contract. It's a First Amendment right to take employment that you choose. But the First Amendment right isn't absolute. There have been some minimal restraints on people's First Amendment rights. The famous saying is you can't yell fire in a movie theater. So any speech that would be likely to harm another person. But the courts really disfavor encroaching on people's First Amendment rights, and this is an example of that.
So I guess if I'm a former lawmaker, there may be a cause that I'm passionate about that would be violating my First Amendment rights if I can't go lobby about it. Is that the idea, Eric?
I guess that's the argument. You don't win friends and influence people by contradicting a federal judge. But he is in mid-Missouri. I don't practice very much there.
So let's let her loose, Eric.
Yeah, I think it's an unreasonable decision. I think 6 months is a reasonably period of time for somebody to sit out. I think that what distinguishes this from the 2024 case by the judge's own admission is the length of time. So I don't think it's unreasonable to ask an elected official to not lobby the body that he used to work for 6 months.
Yeah, Eric, I mean, you make a great case. When they struck down this ban in July that Sean had referred to, at that point it was a 2-year ban. And the court wrote this, quote, similar laws enacted in other states suggest that Missouri might have been able to get by with a shorter period. Its own expert highlighted some of the possibilities from 6 months, like North Carolina, to 1 year, like New Mexico, even though both states have 2-year election cycles, like Missouri. So you would think this 6-month ban might be just fine, that court was saying, okay, 2 years is way too long, but some sort of ban. Sean, do you think this is the end of any ban whatsoever?
I don't know the answer to that. I mean, I think that's a fair question to ask. This court in particular, whenever they looked at the time period, they were still looking at the actual injury to Tony Levesco, who was saying, that, look, I want to go do this. I'm being prevented by my First Amendment rights. I can't take any preliminary steps whatsoever in lining up a client for fear that, I might be in violation of this law and incur some kind of criminal liability or civil liability. And so, I think that, if, the Missouri Ethics Commission or the state wants to, appeal this and get a clear, ruling on that, they certainly can. But right now, I don't think in the order that I read, the focus was really on the time period as some exception to the rule.
And there's all kinds of ways that can be circumvented. You can still be on the payroll of the lobbying entity as a consultant and then just let the entity benefit from your institutional memory by telling them effective strategies that might work for this legislature as opposed to another legislature, but you're not the one in that direct communications with the legislator.
So the way the law is currently written, you could do that sort of activity.
My understanding is yes.
Just can't be there schmoozing, but
right.
People want to schmooze. All right. We'll see what happens there in the Western District. More news on the state front. We now know who has the power to appoint prosecuting attorneys across the state of Missouri. And it turns out it's not the person who's been doing so for decades. That's the county executive in a given county traditionally has handled this function. Instead, we learned via a lawsuit and the fight to replace St. Louis County prosecuting attorney Wesley Bell, it's actually the governor who has this power. Appeals Court Judge John Torbitsky wrote, quote, the language of the Missouri Constitution and statutes leads this court to the inescapable conclusion that the prosecuting attorney performs essential state government functions. As a result, St. Louis County's charter provisions are, quote, subject to the statutes of the state enacted by the legislature. The statute unambiguously grants the governor the authority to appoint a competent person to fill the prosecuting attorney vacancy. So this language, unambiguously, it feels like there was a lot of ambiguity in this. We ended up having a fight. We had decades of people doing it a different way. Susan, how can the court say this is unambiguous?
Well, I think you have to remember that the reason this is controversial is because we had a Republican governor who wanted to do the appointment versus, Sam Page appointing Court Van Astren in a Democratic pick. So that if those two had been in alignment, we never would have heard anything about it.
Sort of like when we had a vacancy in St. Charles County, Governor Parson just stood down and let County Executive Steve Ellman handle it.
Right, but Sam Page is not Steve Ellman, and so that's the controversy. I am one of those people who believe that that it was a correct decision. I do think that the state has that appointing power, whether we like it or not.
I agree. When I was an assistant circuit attorney, the pleadings that I filed was State of Missouri versus John Doe. When I was city councilor, the pleadings that I filed read City of St. Louis versus John Doe. Well, the mayor appoints the city councilor, and the governor can appoint the prosecutor.
Yeah. I think, it is interesting. It felt very ambiguous a couple months ago. Now it feels like people are saying, okay, this is the facts, whether we like it or not. And I should mention, to your point, Susan, even though this was an appointment made by a Republican governor, he did choose a Democrat to fill this position. It's just the Democrat did not get to choose a Democrat. Do you think there's going to be any ramifications because of this ruling that the Missouri Supreme Court has affirmed that the governor gets to make these kind of appointments? I have heard defense lawyers say, well, this invalidates the pick of these past county prosecuting attorneys where the county executive made the pick. And Gerald Christmas, good defense attorney in town, he had said, I'm going to file to have those cases thrown out, to say that prosecutor was not rightly appointed. Susan, do you think there would be any success in pursuing that legal strategy?
I think it's a very creative strategy. I don't think that it's going to have legs. This prosecutor has been duly appointed. That legal decision has been made. I think to try to make it sounds like maybe he's making a jurisdictional argument. And so if you don't appoint the right prosecutor, they have no authority to prosecute. And I don't think that that's the case here.
This is not something the St. Louis University Legal Clinic will be spending time pursuing?
No, it is not.
No. Well, I guess that tells us. If you have a question or comment about this topic, you can give us a call. We're at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air. I want to linger on St. Louis County for just a few more minutes here. That new prosecuting attorney, Melissa Price Smith, once she took office, she swiftly threw out a high-profile prosecution. These were the nepotism charges against County Councilman Dennis Hancock, who had briefly hired his stepdaughter for a county position. Smith suggested that prosecutors may have violated rules about gathering evidence. County Councilor Dana Redwing had questioned County Councilman Hancock about the hire. She recorded this phone call, and she turned over that recording to prosecutors, and she would have been the star witness in the case against Hancock. That's even though the counselor is supposed to represent the council. And the prosecutor, Melissa Price Smith, had suggested that conflict could be a problem if the case went to trial. Eric, you're a former city councilor. Would you have ever recorded a member of the Board of Aldermen and used that against them if they seemed to confess to some sort of criminal violation?
No, I would not, even if I had the legal right to do that, which is arguable. I would not have done that.
Do you believe there'd be an ethical type issue there?
Could be. Yeah, could be. I respect the county councilor a great deal, but I disagree with her actions on this one.
What do you make of this one, Susan?
I think if there's an ethical issue, it's divulging what your client said to you. Mm-hmm. So in a million years, I'm a criminal lawyer, I would not tape anything my client said. But to breach confidentiality by turning that over, I think is questionable. Now, I'm not sure of the exact attorney-client relationship there, but assuming there is one, the only way that counselor could have turned over the information is because she believed she had participated in a fraud somehow. The rules are very clear. There are very limited circumstances in which you can divulge what a client says to you. And the only one I could think that might apply would be that she had been used in a fraud somehow. That is supposed to be inviolate. I teach my law students, don't you ever tell anybody what your client said to you.
And you mentioned you go so far as you would not tape your client. I feel like everybody now is taping people so they can later get a transcript of it. Why would you not want to have a tape just, so your records would be complete?
Because there's no way that would benefit my client. And my obligation is to my client first. I really can't think of something that my client would say to me that I couldn't just write down instead of having them tape. And in today's hacking, world that we live in, I don't want someone else to somehow make their way into my file and find let's say a confession from my client. So if the action is not going to benefit the person to whom I am obligated, I am not going to take it.
And just to reiterate what you were saying there, if the county councilor had an attorney-client relationship with the county councilman, which I know this is slightly more complicated than as simple as, one of the clients that you have might hire you to deal with a criminal matter for them. This is somebody who represents the body, but they seem to also represent the people on the body. That could well be an ethical violation if that was turned over.
It could be. If I did it, it would definitely be an ethical they'd pull my ticket, as we say. I would not have a license anymore. But I'm unsure of the exact nature of the attorney relationship between those two parties. There may be some sort of exception or relationship part that I don't understand.
And Eric, this is kind of a moving target in that I know the county council has said, we don't feel like the county councilor acts in our best interest.
Which is why there's a move afoot for them to be able to hire their own attorney. And I appreciate the sentiment that the county council is offering, but I disagree with that. There is ample precedent of a legal department, especially a governmental legal department, representing different entities. Because when I was city councilor, the mayor and the city comptroller were fighting each other all the time. And one attorney represented the mayor, and the other attorney represented the comptroller.
And these were both attorneys in your office?
Yes.
And that worked out fine?
Yeah, it was kind of dicey at times, but, you set up a ethical wall between them, and life goes on.
And you could make it work. Susan?
And I'll just mention, attorneys are responsible for figuring out their own ethical conflicts. So if this attorney had realized that she represented the body and that one of the members of the body was working against the best interest of the body itself, well, then she would have to disqualify herself from representing one or the other of the clients.
And make that clear to the client? Like, I am not your lawyer here.
Right. Under Missouri ethics, you would need to get off both cases.
Okay. Well, I tell you, the county is always a wellspring of legal complication. That remains true here. If you have a question or comment for our panel, again, phone lines are open, 314-382-8255. That's 382-TALK. We're talking to our legal roundtable. That's Susan McGraw, Eric Banks, and Sean McLean. When we come back, we'll talk about presidential pardons and a complaint over the mighty midgets. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our legal roundtable. And I have a panel of three great attorneys with us today. That includes Susan McGraw, who's a professor at the St. Louis University School of Law and director of its Criminal Defense Legal Clinic. We're also joined by Eric Banks, a former city councilor for the city of St. Louis and an attorney and mediator at Banks Law. And making his legal roundtable debut today, Sean McLean. He's a partner at the law firm Mickus O'Toole. He focuses on labor, employment, and education law. And I think we're all in agreement. Sean has the best voice for radio of any lawyer we've ever had on this show. So we all stand down and salute your dulcet tones, Sean.
Thank you.
So, at the very end of his term, then President Joe Biden commuted the sentences of 2,500 people with various drug sentences. And then President Donald Trump was swept back into office, and he pardoned 1,500 people who'd been convicted of storming the U.S. Capitol in 2021. So these are big upheavals in the criminal justice system. Mass pardons, mass commutations. What exactly do they mean? Susan, what is the difference between commuting a sentence and pardoning someone?
Right. So when you commute a sentence, you're changing the sentence. You usually commute the sentence to, let's say, time served. So President Biden commutes these sentences. These people still carry the conviction on their record. However, they are released from their prison sentence. In a pardon, you erase the whole conviction, both what's on. So these folks won't have a record. Because they have been pardoned. It's become a nullity. So they no longer have these convictions versus a commutation, conviction, but no time.
Okay. So a pardon is kind of like it never happened.
Yes.
And call me old-fashioned, but I think that being part of a group that assaults 140 law enforcement officers, or being part of that group, is light years different than commutating or pardoning a drug dealer.
Yeah, I mean, these are two very different groups of people. You make a good point. Now, I talked to attorney Al Watkins, one of the more quotable attorneys in town. He also has kind of a voice for radio. He represented the QAnon shaman. This is Jacob Chansley. He was in the U.S. Capitol sort of bare-chested, wearing this crazy sort of headdress, and was one of the more prominent people who got this pardon. He told me this. He said, President Trump had the opportunity in 2021 to pardon the January Sixers. He chose not to do so. Instead, he pardoned Lil Wayne, apparently prioritizing a hip-hop artist over these peaceful protesters. Obviously has a different take on that than Eric does. He said, I agree with President Trump pardoning the peaceful protesters. Unfortunately, he was a day late and more than $1 short. Sean, one of the points Al was making to me there was that most of these people had already served their entire sentence. So what good does it do to get pardoned if you've already done your time?
Yeah, I mean, he does have a point that the president could have done this earlier and did not. And, these folks did go through the process, and there's, some level of reputational damage. I think, that's something that some people have talked about is that, while they have a pardon and, maybe they did not, for those that were convicted and did start to serve time, they will have this on their public record, so to speak, if the conviction is erased, people will still know about this. So, to some extent, I suppose I do understand what he's saying. But on the other hand, I mean, I do think, many of these people, have not actually been convicted yet. They were going through the legal process. As we all know here at this table, the legal process is very slow. Justice wheels are slow, right? And so, some of the folks here in the St. Louis area who receive these pardons, I think several of them have not been convicted yet and had not served any time yet. So
there was one, the famous rally runner. This is the guy who used to run around Busch Stadium, thought he was somehow helping the Cardinals. He was currently serving his sentence, and he got sprung. Susan, I saw the QAnon shaman tweeting that he could go out and buy some guns. Is that sort of also a perk? You don't have to worry about being a felon in possession if your felony goes away.
Right. It's a perk. I mean, I think we have to ask ourselves whether that benefits all of us. That people who have been convicted of assaulting police officers are now free to buy a weapon. But that's true. If they get pardoned and that conviction is nothing, again, if you have a commutation, you still have your record. So those people cannot buy guns if that is what your intent is.
Okay. But the J6ers can. The drug people commuted by Biden, they cannot.
They cannot. The people who were pardoned are back to where they were before this conviction.
I want to go to the phone lines. We have Elick calling from St. Louis County. Elick, hi, you're on St. Louis on the air. I think we may have lost Elick. Well, that is unfortunate. Okay, well, we will be moving right along then. So here's a question coming out of Illinois. Does calling a school mascot the Mighty Midgets violate federal law? That's the question being asked by some activists about the high school in Freeburg, Illinois. The mascot there has been the Midgets for 90 years. It's apparently a tribute to a basketball team that had no tall players, but punched above its weight. I think I'm mixing metaphors on that. Well, this fall, a group led by adults with dwarfism and parents of children with dwarfism lodged complaints against Freeburg High with the U.S. Department of Education's Office for Civil Rights. The Mascots Matter group accuses Freeburg of violating federal anti-discrimination laws by creating an environment that is hostile to people with disabilities. Eric, do you think they have a good case?
I would not be optimistic, given the present administration, that argument is going to get any place.
Yeah, I mean, we have a Department of Education that is now being run by appointees of President Donald Trump. They may take more of a dim view of this one. It's maybe not as clear-cut as if there was a mascot that seemed to be mocking a particular racial group. We know that racial groups are protected and that we can't have things that are against women or things like that. But their shortness is part of their disability, which is apparently dwarfism. Susan, do you think that opens the door to then say the midgets are beyond the pale?
I mean, this is kind of above my pay grade. I would say, instead of just referring to people with dwarfism, I think we need to acknowledge there are accommodations that need to be made for people who are in that situation. And I think to that extent, it is, however it was conceived, it's in, I think we can all agree, terribly poor taste now.
Absolutely.
Yeah, and this has been going on for 90 years. I will say, even before President Trump coming back into the office, so the Office for Civil Rights determined the Wichita North High School Rednecks name didn't create a hostile environment. This was 28 years ago. A similar complaint filed by the Michigan Department of Civil Rights was also unsuccessful in 2013. Apparently, they didn't have specific examples of students or individuals who were harmed by these mascots. So this may come down to whether they can show someone who's been harmed by this. As Eric says, it just may come down to the fact that this is not going to be a high priority for the Trump administration. So speaking of regime change in Washington, it has triggered many changes affecting diversity, equity, and inclusion initiatives. Here in Missouri, a group of lawyers holding elected office want it to affect training for lawyers. U.S. Senator Eric Schmidt has joined with top state officials, including Lieutenant Governor David Wassenger and Attorney General Andrew Bailey, to petition the Missouri Supreme Court to drop a requirement that lawyers complete DEI classes as part of a mandated continuing legal education. Apparently, lawyers have to get 15 credit hours for various subjects, including 50 minutes of training that includes, quote, implicit bias, diversity, inclusion, or cultural competency. I imagine all of you here on this panel have taken these classes. I'm wondering, Sean, is this something that has been helpful in your work?
Yeah, I mean, I think, these CLEs, like any CLEs, some can be more helpful than others depending on the way it's presented and the material. And, I've taken, the elimination of bias credits, which I think they're typically colloquially known as, and it's things like disability discrimination is one that I'm signed up for here soon. And as a, employment attorney, I find that pretty helpful to my practice area to talk about disability discrimination and things like that. So I think, certainly, I have found that these have been helpful, and kind of curious what the other panelists would have to say as well.
Yeah, I mean, they're saying this is politically charged indoctrination. Susan, has that been your experience?
It hasn't, and I've taken a lot of CLE in my time. I'll tell you that our law school prides itself on the fact that we build DEI into our curriculum. I'm from a suburb of Chicago. I came here and started being a public defender, and I had absolutely no experience with people who are marginalized. And it is, to do a good job as a lawyer, you have got to understand where your client is coming from. And taking a 1-hour class a year is such a simple way to discover maybe things about people that you didn't know that it will assist you in your representation. So I think they could have spent that hour writing that letter, doing their DEI training, and they would have been all done. It's theater. That's what this is.
The letter.
The presiding judge does not need to change everything because Eric Schmidt and some of his and she is a judge who can hold her own.
This is Justice Mary Russell.
It is, absolutely.
Yeah, I mean, there's been kind of this movement on DEI where people are proactively getting rid of these departments, getting rid of these classes. They're not waiting to be told they can't. They're saying, all right, I'm done with this. Do you think the Missouri Supreme Court will take that tack?
I don't think so. I mean, I can remember these things have been around. It's not a new movement. When I was a young public defender, we took a training on implicit bias and getting to know the people you represent who don't necessarily come from your community. I can't see that changing.
Eric, I'm going to give you the last word on these ones. Have they been helpful for you?
Absolutely. I am thinking about not renewing my Sam's Club's membership and getting a Costco membership as well because of the very strong position that they've taken in favor of DEI. And why did they take that position? Because it's justified from a business perspective. The more you understand your customer, the more money you're going to make. And that's the way it is with the legal profession. The better we can relate to all kinds of people and to be sensitive, the better lawyers we're going to be.
We're talking today to our legal roundtable. That is Eric Banks. We're also joined by Susan McGraw and Sean McLean. Coming up next, a Christian camp wins a legal victory after a past camper accused it of hiding sexual misconduct. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm here today with our legal roundtable. This is once a month. We get together with some of the top attorneys around the St. Louis area and just chew upon the matters of the law, some of the high-profile cases that have been in the news in the last month, and sometimes also things involving the legal profession, like talking there about the continuing legal education classes that the lawyers that work in the industry are privileged enough to be a part of. And we're joined today by three top attorneys. That's Sean McLean. He's a partner at the law firm Mickus O'Toole. He focuses on labor, employment, and education law. We're also joined today by Susan McGraw. She's a professor at the St. Louis University School of Law, director of its Criminal Defense Legal Clinic. And last but never least, joined today by Eric Banks, a former city councilor for the city of St. Louis, and he's now an attorney and mediator at Banks Law. So a Christian camp that's dealt with lots of allegations of sexual abuse won a legal victory this past month. A Christian County judge said Kanakuk Ministries and its insurer are not liable after allegedly concealing knowledge of sexual misconduct at the camp. The case was brought by Logan Yandel. He was abused by the camp's then director, Pete Newman. He won a $250,000 legal settlement in 2010, and Pete Newman is now serving 2 life sentences for abusing multiple children. So there doesn't seem to be much question here. We know this guy did it. Well, when Logan Yandel sued back in 2010, the camp's CEO allegedly lied to his parents and said, quote, nothing's been on their radar about this guy, Pete Newman. They said that's why they signed this settlement and agreed to go away with just $250,000. Now, this Logan Yandel said he learned in 2021 that had been a lie. And so he sued. The judge ruled that he should have learned about the camp's negligence years before that. So, Sean, how was he supposed to know that? If the camp lied to him, how does the statute of limitations play into this kind of lawsuit?
Yeah, this is a really interesting one, I think. The actual claims in this were fraud and conspiracy. And here in Missouri, a fraud claim, you've got 5 years from whenever you knew or should have known when the fraud occurred. And so in this particular case, the original lawsuit was settled back in December of 2010. And what the court said in their order on this, when they dismissed this new case, they said back in August of 2010, the plaintiff had actually been at the CEO's house, where the CEO at the time was openly discussing all of Newman's inappropriate conduct with other boys at the camp, and stated that, those incidents would soon become public to everyone else. And so, the court really looked at that as saying, between that, statements by the prosecutor that was in the public, things that were in the newspaper, the plaintiff really should have known, way sooner that these statements may not have encompassed the entire truth. And on top of that, fraud is just a really tough claim in any place. So, there's a lot of, they really look closely at the conduct of the parties whenever they determine whether or not there's a claim for fraud. So, when the judge was looking at this, he's pointing at this specific incident that happens back in August and says, look, this new case was filed, in 2022, and you should have known at least by 2017 that all of this other conduct had occurred, and so that's the statute of limitations. You've lost out on your claim, any potential claim, and so the conspiracy claim they dismissed too because it's dependent on the fraud claim. So he just dismissed both of them.
Okay. So this idea of fraud being particularly hard to pursue, if you're trying to help somebody who's been the victim of an institution like a camp or like a school, it sounds like fraud would not be the way to go if you have another pathway.
Yeah, I mean, I'm an education attorney. We don't see a lot of fraud claims because, it's just this is I think a novel type claim in this particular case. It really has nothing to do with anything other than one specific statement that was made by the CEO. I look at this order, it's I can understand kind of where the judge is coming from here.
So the issue of statute of limitations, this is something that laymen like myself are constantly talking about, and we have no idea what we're talking about when we talk about this. Susan, how important is the statute of limitations for pretty much everything you deal with in the law?
Right. I mean, both civil, which is lawsuits, and criminal, which I do. And it's really the law's way of saying you have to attempt to prosecute your case civilly or criminally within a certain time frame, because no one can defend a case that's brought 30 years after it happened. Only murder doesn't have it, and child sexual abuse doesn't have a statute of limitations. And it's a way to ensure that the parties get a fair opportunity to defend their case, because it's going to be fresh enough that you can find witnesses and you can find records.
It's interesting that child sexual abuse gets that carve out. Do we know philosophically what the reason for that is?
Well, the reason is it's so unlikely for children to report sexual abuse. They might not understand that what happened to them was bad. They might not report it because they're embarrassed. So the law makes like you said, a carve out for situations where someone was sexually abused as a 4-year-old, and it's not till they're a teenager they begin realizing that the problems they're having now are tied into the sexual abuse they suffered when they were 4 or 5 years old, even 11 or 12.
And so the law will then let you take that in a way that you might not in a different sort of harm caused to a different sort of person.
Right. I mean, it's because children are so exceptionally vulnerable.
Mm-hmm. So we have this lawsuit basically ends up getting thrown out. They can't pursue this. Again, statute of limitations problem. Eric, what do you make of this idea? Do you think that, plaintiffs have to be out there sort of discovering what's there? They have to be actively Googling what's out there?
Well, first of all, I don't believe for a New York second that those parents did not know about these other allegations when they settled the lawsuit. Yeah. I believe that their settlement was like most settlements. It was a calculation of the risk of going forward as opposed to a payday today. In other words, a fast nickel beats a slow dime. So the parents made the strategic decision to cut our losses, to minimize our risk, and settle this. And now, 15 years later, they say, oops, well, we want to get another payday. I'm not buying it.
Yeah. Sean, do you think judges are less likely to try to reopen things that have already been settled? Is that almost something that makes this harder as well?
Yeah, I mean, absolutely. I mean, when a case settles, you have someone sign a full release, and you write them as long as you can, right, in order to foreclose anything like this. And certainly, plaintiff's attorneys can bring novel claims, but the idea is when you resolve a claim, then the parties can walk away and not have to come back to relitigate the same issues in the future.
Yeah, the court doesn't want to have to redo the same cases over and over again.
Absolutely not.
Yeah. So the Eighth Circuit weighed in this past month on a potential class action lawsuit that posed a simple question. Can a lender keep a car title for 15 days after a borrower pays off the loan? The law says in Missouri that lien holders shall release a lien within 5 days. Now, a company called Santander Consumer USA had a policy of not doing so for 15 days. I'm reading this, I'm thinking, okay, this is very clear cut. They're not allowed to do this. Bring on the big class action verdict here. Well, a guy named Robert Gallagher sued this Santander Consumer USA over this policy, and he lost. How is that even possible? Eric, what's the problem here for Robert Gallagher?
Well, I think that the problem is the computation of damages. I don't think that he showed sufficiently to the court that he was harmed by this policy. However, I, once again, disagree with the judges because I think that 5 days means 5 days.
Yeah.
And, I think if I'm a used car dealer and somebody has been making their payments faithfully for about 71 months, and there's a month left on the note, I should start getting my paperwork together, because if they made their payments faithfully for 71 months or 59 months on a 5-year note or whatever, chances are they're not going to default at this late stage.
Right.
So they had more than enough time to prepare those documents.
Yeah, I mean, if the law says 15 days, if the law says 5 days, how is it okay to take 15 days? Sean, help me understand here.
Yeah, so I mean, the court looks at standing here. That's what they're doing. They're looking at whether or not there's some actual harm here. And so what they say is, we've got to have a concrete harm in order for there to be standing by these class action plaintiffs. And they say, look, there's no evidence in the record. So they're looking at the actual record, and we can say, look, like the law is the law, but they're saying, like, in this particular case, there's no evidence of financial harm. There was no impact on someone's credit rating. And even when you look at, intangible harms, and the court goes through it and they talk about some really, stuff that's out of my realm, like cloud on title. I've never heard of some of the things that they're talking about here. But they come back to it at the end of the day and say, look, these plaintiffs, they didn't show any concrete harms that would give them standing to bring their claim. And so they say, look, they acknowledge, I think the court acknowledges that, yeah, I mean, the law says 5 and there's a policy of 15 days. But at the end of the day, these particular plaintiffs, they don't have standing to bring a claim.
Yeah, I mean, I feel like we've been talking about standing on the legal roundtable a fair amount in recent years. It seems like it always comes up when there's one of these big federal cases, like Eric Schmidt is trying to sue the Biden administration. And it's like, can you actually show that there is a victim here? Like, how does Missouri have standing to bring this claim? So the idea is not just that you have to be somebody who's affected by a policy, but you have to be affected to the point that you have harm. Susan, is this a sort of standard idea here?
Well, there's two pieces to a civil suit. One is wrongful, and this is very simplistic, wrongful conduct and damages. A massive case like a class action lawsuit involves a lot of time and a lot of money. And to allow a case to proceed, you would have innumerable plaintiffs, defendants. The legal bills would be enormous for people trying to defend against this suit. And they're saying, look, we're not going to, in my opinion, we're not going to invest in this enormous procedure when there's just not any harm to those 10 days of not having your title.
Sean?
Yeah, and I was going to say, I mean, I agree with all of that. And, I mean, the court even goes a little further. They say, their practice of holding the title for 10 extra days might be frustrating, might violate Missouri law, but it doesn't automatically result in an injury, and not all inaccuracies cause a harm. And so, when we're looking at, civil cases, we do look to see that there's at least some kind of concrete harm, even a concrete intangible harm, right? Something that we can point to and say, that there has to be some kind of remedy here, and the court found that there just wasn't that here.
So if this guy had brought this case and said, this is causing a huge problem, I want to sell my car within 10 days, and this held me back, that might have been a whole different ballgame?
Yeah, I think that might have been a different case, but there's no evidence like that in this case. And the court says, like, he didn't try to, sell the car. There wasn't some kind of impact on a credit rating. So not here.
Well, better luck next time. All right, final few minutes here. An assistant county prosecutor in Jefferson County lost his law license after a courtroom prank. Tom Hollingsworth was stripped of his license after taking advantage of a public defender's laptop being left unattended. He sort of hopped onto this laptop as it was there in the courtroom, fired off an email to County Sheriff Dave Marshak saying, quote, "David, you look so good in khaki pants and that black shirt." Now, Hollingsworth later admitted that he was the one who sent it using this public defender's laptop. He said the sheriff was contacted immediately and was told it was a joke. And then Hollingsworth office suspended him for 2 days without pay. But then he also lost his law license, which is a pretty big deal. Susan, this feels like a harmless prank. Do you think losing his law license is overkill?
I would say that it's not just this conduct. Remember, we talked about confidentiality and how that is paramount in criminal cases. Well, this person accessed the other party's laptop, and maybe it was harmless this time. But what if he had been able to look at an email from a client discussing the case, or even worse, this defense attorney's notes about what they're going to do and what the client said to them. So I think that's why it's been taken so seriously. And I think also the content of the message was just an incredibly poor taste. And that's why they landed on them. It's, there are times when defense attorneys and prosecutors become friends and sit around together and wait for verdicts and do things like that. So they probably didn't know how bad it was going to be.
Yeah, this person thought it was funny, but did it not land that way? That's, ugh. Yeah, I mean, Eric, as Susan mentions, the content of this message, it almost feels like it could be like sexual harassment towards the county sheriff, which is an awkward thing for a public defender. What do you make of this?
Well, back in the dark ages, when I was a circuit attorney, we didn't even have laptop computers, so this would not have been an issue back then. But suppose somebody had a journal that they left in the office, and somebody tore a page out of the journal and sent the message to the sheriff. I think it would have still been just as reprehensible. I am not convinced that the punishment fits the crime. I think there may be a public reprimand, an admonishment. There are all kinds of options that the court could have let fly. However, the court did take a kind of sort of middle of the road, because he can reapply after 30 days, 6 months, or whatever. So it's not a permanent suspension, but it does seem a little bit severe under the circumstances.
Susan, last word here.
Yeah, I think this is a shoot the first hostage situation, that the court was going to make clear if anybody had any intention of doing something like this, they are not going to do it now.
Yeah, this is a prank we will not see replicated. Well, that's a perfect note to end this show on, the Legal Roundtable. It's important that we're letting all local attorneys know you can't grab someone else's laptop and send a vaguely harassing message to the county sheriff. We have now laid down that precedent. Susan McGraw, professor at St. Louis University School of Law, director of the Criminal Defense Legal Clinic, thank you so much for joining us and filling in today.
You are so welcome.
And Eric Banks, attorney and mediator at Banks Law, thank you for joining us.
Thank you.
And Sean McLean of the firm Mickus O'Toole. Sean, you've been such a great addition to today's panel. I hope we can have you come back.
Thank you. Would love to.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr.
This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.